The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I'm Attorney Andrew Branca for Law of Self-Defense, providing guest commentary and analysis of this trial for Legal Insurrection. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members' legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, what can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife, Emily, is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Anyone interested in our free podcast version of our daily legal commentary and analysis of the Chauvin trial can access the Law of Self-Defense News and Q&A podcast, available on most every podcast platform, including Pandora, iHeart, Spotify, Apple, Google. You can just get a simple RSS feed if that's what you prefer for your own podcast player. You can get all those links at lawofselfdefense.com/free podcast. Okay, folks, a quick overview. Today's court proceedings brought us a mere 3 states' witnesses, although undoubtedly the state considered them among their most important. The first was Dr. Bradford Wankhede Langenfeld, the emergency room physician who treated Floyd and whose testimony did literally nothing to diminish the theory that Floyd died of impaired respiratory function induced by fentanyl overdose. Like every witness for the state so far, Dr. Langenfeld's testimony had the appearance of being compelling right up until it was subject to the rest of the story on cross-examination. Much the same could be said of what might be referred to as today's star witness, Minneapolis Police Chief Medaria Arredondo. Chief Arredondo gave the prosecution the headline quote, "They'd certainly prepared for effectively that Chauvin's neck restraint was not MPD trained, period." But again, much of the apparent power of this quote was gutted on cross-examination by defense counsel Nelson. By the way, the fact that the media will only cover direct questioning in this case, however, and will substantively ignore cross-examination has real implications for race relations in America generally and for urban infrastructure in the immediate aftermath of this case specifically. Before I get to that, the final witness of the day was relatively brief, and that was Katie Blackwell, commander of the MPD training division, or at least she was around the time of May 25th, 2020. She has a new job now, as I'll describe when I get to her. That, of course, was the date of Floyd's in-custody death. Like Arredondo, she too testified to the effect that she didn't recognize Chauvin's neck restraint as trained by MPD. She specifically said, "I don't recognize that as something that's trained by MPD. Nevertheless, that's a far cry from the technique constituting murder for reasons I'll discuss below." As usual, the testimony of every one of today's witnesses, whether it's on direct or cross or redirect or recross or even re-redirect in one case, is embedded in the text version of today's content if you'd like to see their video testimony for yourself. So the first state's witness was Dr. Bradford Wankhede Langenfeld. who was the emergency room physician who treated Floyd upon arrival at Hennepin County Medical Center, delivered there by ambulance by paramedic Derek Smith and the driver of the ambulance, the second paramedic, whose name escapes me at the moment, but whose testimony we covered previously. The testimony of Dr. Langenfeld has followed what has become a common pattern in this case. The carefully prepared state's witness is carefully questioned by the state to elicit headline-worthy quotes, but it's ultimately revealed on cross-examination that those quoted opinions were based on extremely limited information, lacked context of the full circumstances, and were gutted on cross-examination as a result. This pattern actually raises a very interesting and alarming public policy danger based on the media's coverage of this case. From what I've seen of media coverage, which for me occurs only when the court recesses during the day for a morning break or for lunch, and the talking heads pop up during the break, and that's all the exposure I get to the media coverage. But it seems to me the media effectively only covers the direct questioning of the state's witnesses. As a result, the public only hears the state's version of the facts. Well, just like if you only hear one side of any argument, it's natural for the public here to conclude that the state is killing it in this trial, and that it's super obvious that Chauvin is a racist police murderer. What's wrong with you, you Nazi? Well, there's a reason that our legal system is adversarial in nature, however, and that's for the obvious reason that there's always two sides to every story. It's only by listening to both sides with their individual strengths and weaknesses that one can have an overall informed opinion about what likely happened. The jury in this trial will get both sides and hopefully arrive at a verdict based on both sides. They're in the courtroom. The public, especially the public willing to riot, loot, and arson must be a verb by now, right? That public is, however, hearing only the narrative of guilt in this case. That means that anything other than a guilty verdict can only come as a complete shock and outrage to their sense of justice, and therefore a complete justification of any terror they wish to bring to bear to the public generally. And who's responsible for this? Well, the rioters, looters, and arsonists are responsible for their own conduct for certain. It's kind of hard to not also assign blame to the media who's pouring out the gasoline across the public square and handing out the matches. That's pretty much all I have to say about that, at least for today. But for those of you who partake of my law self-defense analysis, to make sure you get exposure to both sides of the story, it's a smart move, and thanks. Okay, back to Dr. Langenfeld, who was subject to direct examination by Prosecutor Blackwell. As noted, Dr. Langenfeld was the emergency room physician who treated Floyd upon arrival at HCMC, Hennepin County Medical Center. We all know, of course, that Floyd died that night, and it seems likely that Langenfeld essentially considered Floyd dead on arrival. That's not to suggest the good doctor didn't do everything possible to save Floyd's life, but when someone's been in cardiac arrest for 30 or so minutes, well, the odds aren't good. At no time under Dr. Langenfeld's care was Floyd anything other than flatlined in terms of cardiac function. In fact, Floyd had little meaningful cardiac activity when picked up by the paramedics on scene. He had little cardiac activity en route to HCMC, little cardiac activity upon arrival at HCMC, and little cardiac activity after treatment by Dr. Langenfeld. Ultimately, it would be Dr. Langenfeld who would officially pronounce Floyd dead at HCMC, but the likely reality is that Floyd died some considerable time prior to the official call of death. Now, Prosecutor Blackwell made sure to emphasize the importance of initiating prompt care in cases of cardiac arrest, again hitting on the possible criminal liability claim of failure to provide timely medical care by the officers. One money quote from Dr. Langenfeld is that every minute CPR is delayed in a case of cardiac arrest means a 10 to 15% decrease in survival of the patient. Of course, even if that's true, the fact that Dr. Langenfeld possessed this factoid does not mean that it was possessed by Chauvin or the other officers on the scene, who are, after all, police officers, not doctors. Much as was the case with the bystanders, Dr. Langenfeld found himself working with only partial information about what had occurred generally, and about his patient in particular. For example, Dr. Langenfeld had no information about Floyd's apparent ingestion of a lethal dose of fentanyl, methamphetamine cocktail, upon contact by police, and thus could not consider that likely cause of respiratory depression and cardiac arrest result in his differential diagnosis of Floyd. Specifically, in his testimony, Dr. Langenfeld told Blackwell on direct that he had no report that the patient had overdosed on a specific medication for which there might be a specific antidote. In fact, of course, Floyd had overdosed on the opioid fentanyl, for which there is a specific antidote, Narcan or Noxolone. That information, however, did not reach Langenfeld. Now, why didn't Langenfeld know that Floyd had likely overdosed on drugs? Well, arguably because the paramedics didn't tell him. And why didn't the paramedics tell him? Well, arguably because they themselves had probably not gotten that information from the officers on scene. And why didn't the paramedics get the information from the officers on scene? Well, likely because the angry and threatening crowd compelled the paramedics to do a load and scoot to vacate the area of danger, the scene, promptly, very much limiting the opportunity to exchange information with the officers. And that raises the question, did the angry crowd actually kill Floyd by interfering with his effective and efficient and timely medical treatment at the scene? Now, Blackwell spent quite a bit of time in direct questioning of Langenfeld, getting the doctor to opine that the most likely cause of Floyd's cardiac arrest was hypoxia, meaning a lack of oxygen in the tissues, induced by asphyxia, the inability of the respiratory system to deliver oxygen to the biological systems of the body. But folks, none of that, of course, actually settles the key issue of what actually caused Floyd's death. Even if asphyxia caused Floyd's death, that doesn't tell us that Chauvin killed Floyd via mechanical asphyxiation, via compression of the neck and the chest, at least not when there's a perfectly viable and evidence-supported alternative explanation for Floyd's asphyxia, the threefold fatal levels of fentanyl in Floyd's system. After all, as even Langenfeld himself confirmed today in his testimony, the means by which fentanyl kills its victims is by suppression of respiration. That's just another form of asphyxiation, folks, and we have actual toxicology results to support the fentanyl levels. There's literally zero evidence of how much pressure the 140-pound Chauvin might have been applying or not applying to the neck of the 230-pound Floyd. A common theme running through Dr. Langenberg's testimony is this, quote, based on the information I had at the time, well, indeed, that's how he closed out his direct testimony. That is, of course, just another way of saying, I only had limited information about what was going on with this patient and what had led up to his present circumstances, and my expert opinion must therefore be considered profoundly constrained by that limited information. On cross-examination by, of course, defense counsel Nelson, who explicitly asked if a fentanyl, methamphetamine, or a combination of the two could cause the hypoxia observed by Dr. Langenberg, the answer was, of course, yes. Nelson also confirmed that the paramedics had never informed Laudenberg about the possibility that Floyd's condition was the result of a drug overdose, probably for the reasons already discussed, although naturally I'm speculating a bit there. Touching upon the state's apparent line of argument that Floyd's long history of opioid abuse meant he was somehow immune or resistant to fatal overdose, Nelson explicitly asked Laudenberg if a history of abuse meant fentanyl can't kill someone. The answer was, of course, no, it doesn't mean anything of the sort. Nelson also managed to get into testimony the following question, exploring further alternative explanations for Floyd's cardiac arrest. Quote, would someone with a over 75% occlusion of a coronary artery be at substantial risk of cardiac arrest? Close quote. Now, the state objected to the question. Judge Cahill called a sidebar so they could discuss it outside the hearing of the jury. He prudently does not allow arguing over objections in the hearing of the jury, which is a good call by any trial judge. When Nelson returned to question Landenberg some more, he proceeded with a different line of questioning, suggesting that Cahill had sustained the state's objection on the occluded coronary artery question. Now, why might Cahill have agreed to not allow that question? Well, I'm engaging in informed speculation here, but it might be because Landenberg was present as a personal knowledge witness and not as an expert witness. That means he can testify about what he knows personally about the events in which he was involved, but he doesn't have the privilege of an expert witness to opine, give opinions about hypotheticals. If he does opine about hypotheticals, he's engaged in speculation, and knowledge witnesses are not allowed to speculate. In any case, that was pretty much it for cross of Langenfeld. Redirect by Blackwell was, I think, pretty weak, as has been the trend in my observation of his performance in this trial. He touched back upon an earlier Again, weak line of argument. He'd made previously that fentanyl makes people sleepy, and Floyd was patently not sleepy while he was violently resisting lawful arrest, and that must mean that Floyd could not have been on high levels of fentanyl. I just don't get the investment in this line of argument, frankly. We have the definitive tox results on fentanyl levels. There's no doubt about how much fentanyl Floyd was on. They were at 3 times fatal dose. We also have the chemical analysis results of the pills found both in the Mercedes SUV that Floyd was driving and the squad car he transiently moved through. And in the latter, the squad car, the pills were covered in Floyd's saliva and DNA. And the pills were a combination of fentanyl and methamphetamine. Methamphetamine was also found in his body. And the methamphetamine component is obviously, methamphetamine is a powerful stimulant that would explain away the lack of sleepiness. This has already been discussed in testimony in court, so I don't know why Blackwell came back to this. In any case, that was all she wrote for the testimony of Dr. Langenfeld, and of course, the direct cross and the brief redirect of the good doctor is embedded in the text version of today's content. Next up was the state's likely star witness, MPD Police Chief Medaria Arredondo. The first thing it's important to know about Chief Arredondo is not personal to him. It's something that's true of every police chief everywhere. Being a police chief is a profoundly different job and state of being than is being a patrol officer. And it's not merely that the chief is chief executive officer in a system in which the patrol officer is the equivalent of a factory worker with profoundly different job responsibilities and perspectives on their day-to-day work. More important than all of that is that a police chief, and indeed for the most part, all police officers of lieutenant rank or higher, are effectively political officers working within a political environment, and none more so than the chief. In the case of Chief Arredondo, for example, he was appointed to his position of chief by the mayor of Minneapolis, Mayor Frey. This is obviously a political appointment by a political official, which effectively, who is effectively Chief Arredondo's boss. And that makes the chief's job a political job, not a cop job. So when we hear Chief Arredondo testify, that's the filter through which we should understand his testimony, a political filter, and that we should interpret the weight and context of his testimony appropriately. Now, frankly, having said all that, I have to concede, simply because we are aware of this political reality doesn't mean that the jury will be equally aware, and it's ultimately their perception of the chief's testimony that controls the verdict in this case. Now, direct questioning of Chief Arredondo was conducted by Prosecutor Schleider, and Schleider returned to his early emphasis on the quote-unquote soft values of the Minneapolis Police Department: compassion, dignity, guardianship, respect, be courteous, be polite, and all that. There's little or no emphasis placed by Schleider on the protect part of the protect and serve motto common to most police departments. It's as if the assumption is that bad guys will be bad only because the police first failed to treat them with courteous respect. Frankly, that's not my experience with bad guys, but there you go. Now, Arredondo even testified that it's the mission of the MPD to treat all people with dignity and respect above all else. That's a quote. And I have to ask, really? Above all else? Above preserving innocent life? We're going to be careful to treat, say, the domestic abuser with a gun to his spouse's head with all the dignity and respect a non-violent, law-abiding citizen would be entitled to? Maybe. Let me know how that works out for you. By Schleider's telling, and with Arredondo's agreement, the job of the police department was mostly touchy-feely, and any use of force was apparently an implicit indication that the officer involved had failed to do the right touchy-feely stuff first. Schleider spends considerable time walking Arredondo through the MPD's use of force policies, as well several times having the chief read aloud specific highlighted portions of that policy manual. And I'm sure it was pure coincidence that the portion of every single use of force policy that made the policy conditional on circumstances, words like when safe to do so, as circumstances allow, when consistent with safety, when reasonably possible, when time permits, all of that was left unhighlighted by Schleider and thus unrecited by Chief Arredondo. Instead, the selected portions were read aloud as definitive, unconditional statements of MPD use of force policy. This is, of course, wildly, intellectually, and morally dishonest on the part of the prosecution, but we have an adversarial legal system for a reason, precisely to allow the defense the opportunity to point out such machinations. Schleider also spent a lot of time talking about various MPD de-escalation policies, and frankly, what most struck me as he worked through the list of explicit de-escalation options was that either the officers on scene with Floyd had already executed those steps, or the steps were likely not practical given the circumstances. One option for de-escalation was that an officer could call for backup. Well, King and Lane got backup in the form of Chauvin and Tao. Another option, and by the way, also the park officer. Another option was to use verbal commands to de-escalate. Well, Lane did that on his initial approach to Floyd sitting in the passenger seat of the SUV, and to which Floyd was non-compliant. We all heard Lane shout, "Show me your hands." Nope, Floyd would not do that. And then he was forcibly resistant. Other options were the use of barriers. You mean like using a squad car as a barrier? And containing the threat? You mean like physically restraining the threat? It was also important, according to Arredondo, for the officers to get as much information as they could before they responded to the scene. Well, that sounds nice. I guess that would be a good thing. But the notion that the officers are limited to the information offered by dispatch, and dispatch in turn is limited to the information offered by the complainant, didn't seem to enter Arredondo's thinking at all. Somewhat laughably, Arredondo actually suggested that officers reaching out to the community members itself for help is a viable option. Well, maybe I can imagine circumstances where that would be the case, but in this case, were the officers supposed to seek out assistance from who? Maurice Hall, the purported drug dealer in the SUV with Floyd? MMA expert Williams, who was threatening the officers with physical violence? The off-duty firefighter gal who was calling the officers the B word? Schleider also disingenuously referred to a previous argument he'd raised earlier, which was that all this happened to Floyd simply because Floyd attempted to pass a bad $20 bill, an offense normally so minor it's addressed by the police with a mere summons, a ticket, to appear in court at a later date. Surely that's not something to die over, right? Unstated, of course, is that what might have started as a mere bad $20 bill call quickly escalated, and solely as a result of Floyd's own conduct. When approached by officers in his vehicle, he repeatedly refused to show his hands, compelling the officers to draw their service pistols. As the apparent operator of a motor vehicle, there were additional safety grounds to remove Floyd from the vehicle and temporarily detain him, which can include handcuffing, especially given Floyd's size, which technically is not even an arrest. It's just a detention, and perfectly lawful if the detention is transitory without having to meet the conditions for an arrest. But then Floyd went and met the conditions for the arrest. The apparent drugs were discovered. Floyd began to violently resist the officers' commands, then violently resisted lawful arrest, and bang, we were off to the races. And that's all on Floyd. The officers didn't do that. Floyd did that. I'm sure the officers would have been much happier to have simply written him a summons than get into a physical fight with a 6'6", 230-pound man who was disinterested, intensely disinterested, in being arrested that day. Schleider also spent quite a bit of time on the MPD critical decision-making model. I expect Schleider believes this model generally favors the defense, and he's decided that rather than attempt to avoid the model or pretend it doesn't exist, he's going to go hard on offense. And the way he does this is to point out that the critical decision-making model obliges the police to continually consider and reconsider, evaluate and reevaluate the totality of the circumstances in arriving at their use of force and other decisions. And that's true, it does. Schleider is using this argument to suggest that the officers arresting Floyd failed to consider all the relevant factors in a timely manner, continued to use force when the circumstances no longer warranted the use of force, and therefore acted wrongfully. Every time I hear Schleider or anyone else step through the critical decision-making model, however, what most strikes me is the enormous breadth of factors the officer is supposed to consider in real time, in this case while fighting a huge non-compliant suspect, and dealing with an angry, threatening crowd while making an arrest on a busy street with plenty of traffic going by, just inches away. I expect most of us would have difficulty juggling that many decision-making variables even when we weren't physically fighting someone who outweighed us by 100 pounds and might be about to fight all over again. It's all completely overwhelming. And strikes me that the most one could hope for is that an officer does a reasonable job in juggling most of the most important factors. but that there's a lot of subjective judgment calls being made, and the slack cut for imperfect decision-making should be commensurate with the stressors of the circumstances. At the end of the day, I expect this whole line of argument favors the defense, highlights the complexity of the officer's job, than it does the prosecution. Then we get to what I'm sure will be the money headline of the day, and that was when Schleider asked if Chauvin's specific neck restraint was a trained MPD defensive tactics technique. Arredondo unequivocally stated that it was not. So is that all we need to know? Is Chauvin done? Nope, because we have to carefully parse the specific words of the question. The question asked if Chauvin's specific neck restraint was a trained MPD defensive tactic, and Arredondo answered in the negative. But it turns out that, although he doesn't offer this context in his answer, Arredondo's negative response is based on a whole wealth of what he perceived as important circumstances he's not talking about when he gives this apparently definitive answer. Specifically, Arredondo was not testifying that the knee on the neck restraint was contrary to policy per se. He can't say that because neck restraints were explicitly permitted by MPD policy in effect at the time of Floyd's arrest, but rather it's his position that it was contrary to policy for the length of time it was applied. But that's not just a judgment call. There's nothing in the MPD policy about any specific length of duration of the neck restraint. Presumably, the neck restraint is permitted as long as circumstances warrant, which begs the question of what the circumstances warrant, which makes it a judgment call. It's also important to recognize that just because a restraint might not be per policy if used as a defensive fighting technique doesn't mean it couldn't be justified for some other purpose, such as the trained full-body restraint of a suspect believed to be a victim of excited delirium. Another complaint Arredondo had about Chauvin's particular use of force was that the MPD policy in effect at the time allowed only light or moderate pressure to be applied in a neck restraint. Based on Chauvin's so-called shimmy body movements and Floyd's pained expression, Arredondo inferred that Chauvin was applying greater than moderate pressure, which would put it out of policy. It should go without saying, of course, that there's no way Arredondo can know by merely looking at a video how much pressure Chauvin was actually applying. Nelson even asked him if he had a degree in physics. And remember, guilt must be proven beyond a reasonable doubt. Further, we know that the medical examiner found zero indication of trauma to Floyd's neck. As for Floyd's pained expression, we have the earlier testimony of his co-addict lady friend that the same pills had previously caused Floyd an overdose involving such tremendous intestinal and body pain that he'd begged her to take him to the hospital. And this was only about a year prior to Floyd's death and involving essentially identical pills as those he consumed on May 25th, 2020. I have little doubt that Floyd was indeed in great pain, but there's an evidence-based explanation for that pain other than Chauvin's knee. Of course, Arredondo never mentioned a word about Floyd's overdose on the fentanyl methamphetamine cocktail, potentially contributing to his painful demise. After all, even if we presume Chauvin's knee was out of policy, that doesn't mean the knee killed Floyd, given the perfectly legitimate alternative explanations for Floyd's cause of death. Schleider, like Blackwell before him, also touched on the argument that the officers failed to provide Floyd with timely care. Frankly, at this point, I just assume the state decided on how they believe the officers are criminally responsible for Floyd's death and drive it home, if they can. This constant switching of theories of the case is just tiresome by the state. Cross-examination was, of course, conducted by Nelson. Nelson emphasized how far removed Arredondo was from hands-on policing, and frankly, given the hedging in Arredondo's responses about when he was a street cop, it seemed to me likely that he'd only ever physically arrested a very small number of suspects before managing to get himself promoted off the street. It's not a criticism, good for him getting promoted, but it may mean he has relatively little street experience. Nelson also got Arredondo to concede that his expertise on MPD use of force was at the policy level and not at the tactical, hands-on training level. He could speak to what MPD policy might allow or prohibit, but his knowledge of how the officers were actually trained or what they were obliged to do on the street in carrying out their duties was not a topic on which he could claim great knowledge. And here we get to the point in Cross that illustrates how dangerous it is to rely on the media's general coverage of only the state's narrative of guilt. You'll recall that on direct by the state, Arredondo had explicitly stated that Chauvin's knee technique appeared to him not a trained MPD technique, and Schleider had Arredondo quote extensively from that policy, but only certain portions of that policy. On cross-examination, Nelson had Arredondo read aloud the portions of policy that Schleider had skipped, and it was all the portions that made the policies conditional. For example, that the force used by officers must be objectively reasonable in light of the facts and circumstances known to the officer at the time force is used. Nelson also had Arredondo acknowledge that the purported objective legal standard of the U.S. Supreme Court decision of Graham v. Connor, generally agreed upon as a core principle of the MPD policy manual, as it is probably for every police policy manual in the country, at least for use of force purposes. That same decision also required that this purportedly objective analysis consider all the subjective knowledge, training, experience, and circumstances known to the officer at the time. Further, Graham v. Connor cautioned against judging the actions of the officers with 20/20 hindsight, noting that officers often had to make split-second decisions under dangerous circumstances. Perfection cannot be expected from mere human beings, merely reasonableness. When Nelson asked Arredondo whether it was true that all MPD policies relevant to use of force, to EMS response, to medical treatment, whatever, all of them are by their explicit language situationally dependent, Arredondo was obliged to answer, yes, I would agree with that. Several times during cross of Arredondo, Nelson made use of a clever gambit I've seen him use once or twice on other states' witnesses, especially those claiming some level of expertise on a relevant issue. When the witness realizes that Nelson is leading them to a conclusion which they didn't want to agree with, they start hedging their testimony. Well, I'm not sure. It depends. I don't know if I would agree with that. And in response, Nelson would suggest that perhaps it would be better to defer that specific question to, say, a use of force expert. The witness would readily agree because they saw this as an escape from the question they didn't want to be compelled to answer under oath. What this gambit does rhetorically, however, is substantially undercut the witness's apparent expertise on the subject being asked about. It's like, hey, look, even they are saying they don't really know that much about the subject and that we should instead listen to a real use of force expert, which, unstated by the defense will be glad to present to all of you jurors in just a few days. Previously, Nelson had gotten away with this little trick without objection by the state. Today, however, when Nelson pulled this trick several times with Arredondo, Prosecutor Schleider was all over it, objecting each time Nelson made use of this trick on various silly bases. There was really no good reason to object. Despite Schleider's best efforts, however, each time an objection was raised, Nelson would look over at Judge Cahill with the most innocent, "Who, me?" expression you're ever likely to see on a lawyer's face, and Cahill overruled the state's objection. Nelson also explored with Arredondo the reality that there was a distinction between use of force policy on the one hand and permissible use of force techniques on the other. That is, all use of force had to exist within the boundaries of policy, but whereas there might be one best practice, handcuff technique, for example, that was formally taught or trained by MPD instructors, there might in fact be 2 or 3 alternative techniques that, while not formally trained, also fell within the boundaries of MPD policy. And to this proposition, Arredondo agreed. Nelson had, somewhat superficially, less success when he attempted to get Arredondo to concede that a police use of force often looked ugly and unpleasant to bystanders, who therefore might be likely to find objectionable, even perfectly appropriate uses of force. The state objected to this line of questioning as speculative, and Cahill upheld the objection, so Arredondo did not have to answer the question. But of course, the jury heard the question proposed in the first place, and in many respects, the question itself was more important than any answer would have been. Perhaps the most notable line of questioning of Arredondo by Nelson occurred when Nelson showed the chief 2 videos of Chauvin's knee near Floyd's neck, but with the videos shot from different angles. One was the bystander video, the other a body-worn camera video. When asked if the bystander video angle made it appear that Chauvin's knee was on Floyd's neck, the chief answered that it did appear to be located on the neck. When then asked if the body-worn camera video angle of the same moment made it appear that Chauvin's knee was not on Floyd's neck, but on Floyd's shoulder blade, the chief agreed that this also appeared to be the case. Now, the state would respond and redirect by having Arredondo claim that he noticed this discrepancy, but only in the last few seconds before the paramedics swept up Floyd, and that prior to that point, it appeared throughout that Chauvin's knee was on Floyd's neck. But I can't help but wonder if this video angle disparity might not encourage some of the jurors to view the videos with more skepticism than might otherwise have been the case. Video can lie, folks. Importantly, Nelson also got Arredondo to explicitly agree that just because the suspect was handcuffed did not mean they were no longer a threat to officers, to others, or even to themselves. Indeed, Arredondo explicitly agreed that a handcuffed suspect could still be a threat to officers by kicking, biting, spitting, or other means. There was also a great deal of discussion on cross about neck chokes, which means airway chokes in this context, versus neck restraints, which includes both constrictive neck constraints intended to cause loss of consciousness, which is permitted only under deadly force circumstances on the one hand, and neck restraints intended to, restrain the suspect without inducing loss of consciousness, permitted when dealing with non-compliant suspects on the other hand. With respect to the neck constraints, either arm or leg constriction was explicitly permitted by MPD use of force policy at the time. That's since been changed to prohibit it. Frankly, however, I don't really think it matters. Either Chauvin's knee killed Floyd or the drug overdose killed him. There's no actual evidence that Chauvin's knee applied sufficient pressure to kill, and there's plenty of evidence supporting the hypothesis that it was the threefold fentanyl overdose, the hypertensive and cardiac disease, and the poor judgment of Floyd to fight police that caused his death. Further, if Chauvin's knee was not inflicting killing force, it was almost certainly permissible as a restraint intended to protect Floyd from himself, rather than as a use of force intended to neutralize an active threat against others, which Floyd currently wasn't in the moment. Now, there was a bit of redirect after cross-examination. This is where Schleider got Arredondo to state that he'd only seen Chauvin's knee on Floyd's shoulder blade in the last few seconds of the video shown by the defense. And then there was a recross and a very short redirect. But that's about all she wrote for the testimony of Chief Arredondo in this case. So again, as always, the direct, the cross, the redirect, the recross, and the redirect video of Arredondo's testimony is embedded in the text version of today's content. The last witness of the day is Commander MPD Training Katie Blackwell. Her current job is the MPD Inspector for the 5th Precinct, but around May 25th, 2020, she was the commander of the MPD Training Division, including the Academy and all annual and in-service training. Our prosecutor Schleider conducted the direct questioning of Blackwell, as he had done with Arredondo. Much of Inspector Blackwell's testimony was foundational in nature, documenting that Chauvin had taken various use of force, de-escalation, medical, other relevant trainings in the years immediately prior to May 25th, 2020. This was boring, but I suppose it was technically necessary. At one point, Schleider did get Blackwell to testify that a photograph shown to her of Chauvin kneeling on Floyd didn't look anything like anything taught as MPD training. Sounds bad. Again, however, one must take care to parse the specific words of the question and answer. Just because something is not taught as a trained technique does not mean it violates MPD policy. Further, just because something violated MPD policy, even if it did, does not mean that it killed Floyd. Schleider also spent time with Blackwell exploring the issue of positional asphyxia. I feel obliged to note that there's growing evidence from authoritative sources that the whole notion of positional asphyxia is largely hogwash. My own background on this is largely from my training from the Force Science Institute. That's their position, that it's mostly nonsense. They've published numerous papers on this topic. In any case, even if one entirely buys into the notion of positional asphyxia, it is dangerous only in a theoretical way. It's not any kind of guaranteed death sentence. It has the potential to lead to a bad outcome. In contrast, a threefold fatal overdose of fentanyl is guaranteed to result in asphyxia, unless treated with Narcan or something similar, because of its profound effect on suppressing respiration. And we know for certainty what Floyd's levels of fentanyl were from the tox results. Again, the state has to prove guilt beyond a reasonable doubt. Were there no fatal levels of drugs in Floyd's system, positional asphyxia might be a reasonable inference of cause of death based on the facts of this case. In the context of the threefold fatal levels of fentanyl, however, not to mention the comorbidities and the fighting of the police, I don't see how positional asphyxia gets one to guilt beyond a reasonable doubt. And again, it's yet another different angle being played by the prosecution on cause of death. Was it asphyxia induced by compression of the neck and body? Was it positional asphyxia? Was it failure to provide timely medical aid? Was it a combination of all three? By what mechanism? And in all the context of the fentanyl overdose for which only Floyd can accept responsibility. A good indication of the relative unimportance of the Blackwell testimony to the defense is that Nelson spent literally about 2 minutes on cross-examination. During that time, he seemed to be looking to cast doubt on exactly what training Chauvin actually received, regardless of what the formal documentation stated. Any of you who've ever taken CLE or similar kinds of training will understand the possible dynamic here. Just because you got checked off on a box doesn't mean that you actually got the training. But it never seemed to go anywhere, this line of questioning, so he dropped it, and his cross of Blackwell was dropped promptly as well. So again, the direct and very short cross-examination of Blackwell is embedded in the text version of today's content. All right, folks, that's all I have for you today. Join us again tomorrow morning for our live coverage of the Derek Chauvin trial, blogged in real time over at Legal Insurrection, and of course our end-of-day wrap-up legal commentary and analysis done for both Law of Self-Defense and as a guest commentator for Legal Insurrection in the evening after the court has adjourned for the day. Until tomorrow then, I'm Attorney Andrew Branca for Law of Self-Defense. Stay safe.